Yes.
Doing all right?
All right. Hope the gremlins stay away.
Me too. Is Mr. Ellis going to make his announcement?
Mr. Ellis retired on Valentine's Day.
Oh, no. Well,
Would have been interesting. No, I'm the one wielding the gavel today.
all right.
I do not have Mr. Ellis's flair, unfortunately.
That's all right. You can develop it over time.
And one. Okay, I'll get in touch with Fred Wood. Okay, thanks. Mr. Baker says he's in as an attendee. Okay. Not seeing him yet, but I did see his name pop up. There it goes.
Okay, this is, all right.
I can see that, Mr. Baker.
Okay. All right, we're good.
Dan, can you hear me over the WebEx?
Yes, I can.
Okay. Okay, so we are not going to be able to do the practice session, mainly because it's incompatible with the live streaming. So I am getting ready to start the live stream. So just so everybody is aware of that, it is getting ready to go live on YouTube. So I would request that everybody just stay quiet until we get the thumbs up for Dan to start court. Yes.
Fred, this is Valerie Zachary. I received some kind of notice that my webcam was not properly installed.
Okay, I will come down there in just a minute.
Okay.
Mr. Wood, also Judge Zachary has a audio loop going on. That's,
Yes, I noticed that too.
okay.
I'm just causing all kinds of problems today.
We love technology.
I know.
What place?
Great to have this huge screen. Thank you for it.
Yes, ma'am. Well, at some point, I mean, you can leave it muted for now if you want.
Thank you.
Dad, can you hear me?
Good afternoon.
Good afternoon, Your Honor.
Good afternoon, Judge.
A
A few reminders before we get started. It's okay to be a bit nervous today. We are in a practice session right now. We're going to start court in just a moment. But, you know, we're all trying this for the first time. So I just want to put you at ease. If we have any technical difficulties, Fred Wood, the IT director for the courts, the appellate courts, will help us with that. And if it appears the technical difficulties impair the ability of counsel to argue, the presiding judge, that's me, will my discretion pause or add some time to the clock. It looks like you both are choosing to stand for oral argument. Is that correct?
Yes, Judge.
Yes, Your Honor, that's correct.
Okay, great. And when it's not your turn, here's my question. When it's not your turn to argue, if you sat down, would you be out of the view of the camera?
No, Judge.
No, Judge, if I sit down, this is what I'll look like.
Oh, okay. Great. Thank you so much. Very good. Okay. Make sure you've closed out any unnecessary windows on your computer. Judge Zachary, can you say hello and then leave your mic open? Well, while we're waiting for that, Judge Young, can you please say hello and then leave your mic open?
We've got a big audio feedback loop on your audio. Judge Young.
Yep.
Judge Simmons,
Yes.
just making sure you can hear me.
Oh, that's great. That's a
I can
breakthrough.
hear you.
Okay, that's terrific.
Well, I can hear everyone, and I've got a beautiful picture of everyone.
Okay, great. And
Sorry
just
for all the trouble.
okay. And Judge Zachary and Judge Young, just leave your mics open if you will. Unmute yourselves.
Okay.
You need to see what this is going to be like. So, Judge Young, have you unmuted yourself?
Yes.
Okay, it's showing here to me that you're muted, so it doesn't matter. Very well. I'm just going to keep on going.
Judge Inman, there's a lot of feedback with Judge Young's microphone.
Okay, very good.
He's in the system twice.
That's great. Well, while they're working on that, Mr. Lucas, will you just
Excuse
please
me.
say
Judge,
hello
can I
and
fix that? Can you hear me?
Yes, I hear you, and you sound great. There's no feedback.
I can hear you without any feedback.
Great. I'll leave my mic open.
You okay? Very good. Okay. Sorry. Mr. Baker, Can you just say hello so we're sure that yours is working?
Yes, Your Honor. I can hear everyone and everything appears to be working fine on my end as long as y'all can hear me.
Okay, great. And Mr. Tharp, you just say hello. I know we just heard you.
Yes, Judge, I can hear everyone and hope everyone can hear me.
Okay, very well. And Mr. Tharp, I understand that you will go first. You represent plaintiff appellant. Is that correct?
That's correct.
Okay. And I understand, I want to confirm, do you wish to reserve 5 minutes for rebuttal?
Yes.
Okay. If you would, Mr. Tharp, right now mute yourself and just say hello again so we make sure that we can't hear you. We can't hear you. You can unmute yourself now. Thank you. That was perfect. And before we leave this practice session, I'll get you to mute yourself again. I mean, we'll all be muted, I think. And you know, you'll unmute when it's your turn to make your argument, and then you'll mute again when you're not arguing. Mr. Baker.
Yes, Judge.
Do you have any questions about muting and unmuting?
No, ma'am.
Let's test the muting for just 1 minute.
Okay, I'll start
Okay, great.
singing some song while I'm muted.
Oh, that sounds great. I can't hear you. I could hear you right at the very beginning, but the timer will show in a window. Can everybody see the timer? This is the same
Yeah.
timer we use in the courtroom.
Yes, Judge.
It's controlled by Fred Wood, and each side has a total of 30 minutes. When you have 2 minutes left, just like in the courtroom, the yellow light will come on. And when your time is up, the red light will come on, and you are to conclude your argument unless I grant you additional time. Everybody got that?
Yes, ma'am.
Yeah.
Very good. The timer will start when you start speaking. So I'm not sure technologically how that works, but you don't need to wait for something to happen before you start. Do try to avoid speaking when another person is speaking so that we have a clear record. And please silence your cell phones if you haven't already. You might leave it at close by in case we have a technical glitch and Fred Wood or Dan Horn needs to reach you. And at any time, if you feel nervous, take a breath. It might seem like an eternity, but it really will not be. Judge Zachary, do you have anything further before we officially go public and start this session?
No, I have a great picture of everyone and I can hear everyone perfectly.
Okay. Judge Young?
Oh, I can hear and I can see everyone fine. I did, Judge Inman just send you a text, so I don't know if you've got your phone close to you.
Okay, I do have my phone. You know, that is true. Does it sound that way or look that way?
No, it just looks that way.
That is true. I have a treadmill desk. And I will just turn this off. It's just such a habit for me. There we go. So yes, this is me just standing here now.
It's hard for you to do, isn't it?
Huh?
That's hard for you to do.
It's okay. It's okay.
I'm used to standing still.
No, it's all okay. Now we are ready to leave the practice session and go into the light, as it were. And Fred will do that, and then will Mr. Horn say we're ready to open this session, of course.
You want us to mute our microphones?
I think that it's going to make you muted when he takes us out of the practice session.
Okay.
Judge Inman, if I understood Mr. Wood earlier, able to get the practice session to work and be compatible with the YouTube live streaming. So I don't know if we've been,
Okay.
I don't know if we're currently live streaming or not, but I think we're in the.
I just got a text that we've been live streaming this entire time.
Oh my.
And so, I think we have more than complied with our state constitution's requirement that our courts be open and accessible to the public. Mr. Horn, we are ready to open this session of court.
The Honorables, presiding judge and judges of the Court of Appeals of the state of North Carolina. Oh yes, oh yes, oh yes, the Court of Appeals is now in session. God save the state and this honorable court.
Thank you, Mr. Horn. Welcome everyone to this session of the North Carolina Court of Appeals. I am Judge Lucy Inman, your presiding judge for this afternoon's session. Also on your panel today are my colleagues, Judge Valerie Zachary and Judge Reuben Young. The Court of Appeals clerk, Mr. Dan Horn, has begun these proceedings and will gavel us out when we're finished. We are living in unprecedented and uncertain times, and we are doing our best to adapt. North Carolina's Chief Justice Sherry Beasley has entered several orders to allow our justice system to proceed as fully as possible while not endangering the safety of parties, counsel, or court personnel. One of those orders provides for oral arguments in our appellate courts to proceed on a virtual electronic platform, such as the one we're using today. Counsel for both parties have agreed to use this platform, and I'm grateful to you, counsel, for your efforts to carry on and try something new. Counsel, please know that we are all doing this for the first time. So if a technical or logistical glitch occurs, we will all understand and deal with the challenge. Nothing about this new format should compromise your ability to advocate for your clients and for us judges to see and hear your arguments. Are counsel ready to proceed?
Yes, Judge.
Yes, Your Honor. Ready to proceed.
Very well. We have one case on this afternoon's calendar, Tony Ray Simmons versus John Lee Wiles, case number 19-786 on appeal from Cabarrus County Superior Court. We will first hear from counsel for the defendant appellate, John Lee Wiles.
Thank you, Judge Inman, and thank you, Judge Inman, Judge Zachary, and Judge Young for hearing from the defendant, John Lee Wiles, today. I am his appellate counsel. My name is Paul Tharp. I'm a member of the Gaston County Bar. It's my pleasure to be before you today. This lawsuit arose from an incident that occurred on September 19th, 2009. The defendant is a tinkerer. He tinkers with and fixes old cars and other items. And on that day, he was fixing a lawnmower. He went to Northern Tool Store in Concord, which is right off United States Highway 29, to get some drill bits. He entered the store at 3:39 p.m. That same day, the plaintiff, Tony Simmons, was hauling cars between Kannapolis, North Carolina, and Charlotte. And he also stopped in the Northern Tool Store to get a breaker bar, which is a steel bar. It's about 3 feet long. Simmons entered the store about 13 minutes after Wiles. When Wiles parked, he parked near the front door of the store, which is across the parking lot from US 29. However, Simmons, since he was driving a large trailer, parked back by the highway on the far side of the lot from the front door. While inside the store, the two men had words, and according to a store employee who testified named Mike Muller, it sounded like a conversation. He did not detect any anger, and they were not loud. Mr. Wiles, the defendant, left the store at 3:58 p.m. He got into his car, and he moved down a few spaces. His girlfriend, Greta Clark, was with him. Although that was the first time in the store that defendant had ever met the plaintiff, Mr. Simmons. Mr. Simmons was a neighbor of Mr. Wiles' parents, and there had been some disagreement years earlier about some broken down cars that were on Mr. Wiles' parents' land that led to some legal action involving the county. Also, years earlier, pursuant to that litigation, Mr. Wiles had gone out to take photographs of his property and the cars and Mr. Simmons' property. And Mr. Simmons allegedly had shouted obscenities at Mr. Wiles and Ms. Clark and had threatened to take Mr. Wiles' camera and shove it up his you-know-what. These incidents caused Ms. Clark to have some fear of Mr. Simmons. She asked Mr. Wiles to remain in the parking lot for a minute so she could get a look at what Mr. Simmons looked like. Mr. Simmons exited the store at 4:06 p.m., which was 8 minutes after Mr. Wiles. Both Mr. Wiles and Ms. Clark watched him go to his truck, and they believed that he got in his truck and left. However, the next thing defendant knew, he heard Ms. Clark screaming, and he looked up and he saw the plaintiff, Mr. Simmons, running at his car with a breaker bar in his hand, cursing at Mr. Wiles. Mr. Wiles jumped out of the car and ran around the back of the car to stop the attack. He said stop twice. He testified that he was in fear of his life, and he feared that Mr. Simmons represented a threat to Ms. Clark as well. Mr. Wiles drew his personal firearm and fired one shot at Mr. Simmons. This stopped the attack. Mr. Wiles testified that he had no intent to injure or kill Mr. Simmons when he fired the shot. His intent instead was to stop the attack. He said he held the gun with two hands and aimed at what he called the biggest area that I thought would not be lethal. Mr. Wiles remained on the scene as law enforcement came, cooperated with law enforcement. After this happened,
Mr. Tharp, I'd like to
Yes.
ask a question if I can. Do you agree that the elements as stated in our jury instructions for a civil claim of battery are: one, intentional contact, bodily contact with another person; two, that caused physical injury or offended a reasonable sense of personal dignity; and three, were done without the other person's consent? Do you agree with that?
I do. That is a correct statement of our pattern jury instruction for battery in North Carolina.
Very well.
And just as a
And just, if
follow-up,
I can just make clear, is your argument on appeal here only about the intent element?
It's about the intent, but more largely speaking, it's about the ability of a trial court to direct a verdict in the plaintiff's favor where the plaintiff's case relies on the credibility of his own statements and the statements of his own witnesses. And it
If I could just please focus us a little bit. We've heard your summary of your client's testimony. And do you agree that your client testified that he intended to shoot Mr. Simmons, even putting aside the issue of self-defense for a moment, doesn't intentionally shooting someone, even in self-defense, amount to intentional bodily contact?
Intentional bodily contact is not the same thing as a battery. And that's a point that the defendant made at length in his reply brief. There are all kinds of, well, maybe before this pandemic, there were more intentional, non-consensual touchings between persons that do not constitute batteries.
Well, would you say that shooting another person in the stomach is not something that would be acceptable in any context? I know you gave a lot of examples about football players, but do you dispute that your client intended to shoot Mr. Simmons, acknowledging your position that he did so in self-defense?
He admitted that he shot Mr. Simmons. So there's no question that he shot Mr. Simmons. His intent was to stop the progress of Mr. Simmons. And the standard that the trial court must use in addressing a plaintiff's directed verdict motion is the defendant's evidence must be deemed true, and all of the inferences from the evidence must be in the defendant's favor. And you can only make a directed verdict if no reasonable juror would have found in favor of the defendant.
Excuse me, Mr. Tharp. Isn't the standard, that, as long as he intended the act, then that would satisfy that element of battery?
No, it would not satisfy that element of battery. There's still something for the jury to do, and this gets down to the fundamental reason that we have juries. We have juries because of the complexity of existence. Words are unable to capture the complexity of what our brains can do in 1 second and what reality can do in 1 second with respect to the senses and what impressions we have in life. So we asked juries to decide. What the jury was asked to decide in this question was, given the totality of the circumstances, given the totality of the evidence in this case, was this a tort or was it not a tort? Was this the intentional tort of battery or was it not the intentional tort of battery? And that is what the court deprived the jury from being able to do in this case.
Mr. Tharp, if I could just please interrupt you. Mr. Tharp, are you representing to this court that there's no precedent in North Carolina allowing a trial judge to grant directed verdict for a plaintiff on a claim of battery against a defendant in a battery claim?
I have not located an appellate case that sustained a directed verdict for a battery claimant in North Carolina. I have not found one.
Very well. Are you familiar with a couple of cases that don't say that explicitly, but that counsel for the plaintiff argues do say that together? That is Andrews v. Peters, which was a battery case, and North Carolina National Bank versus Burnett, which held that while credibility is generally for the jury, courts set the outer limits of it by preliminarily determining whether the jury is at liberty to disbelieve.
Yes, Your Honor. I'm familiar with those cases. The Andrews v. Peters case is an instructive case as it relates to battery cases. That's a case where a woman was standing at work and she was standing with her knees presumably locked, and a co-employee who was taken on her, walked up, and he kind of put his knee behind the joint in her knee, which made her knee bend, which was a funny trick to play on people in elementary school. But for this woman, it dislocated her kneecap, so it wasn't so funny. So the question in the case was that a battery, what her co-employee did to her knee? Was that a battery? And the defendant in Andrews versus Peters, and this is a case that's actually cited in the pattern jury instruction for intent. In that case, the defendant moved for directed verdict, and the court denied it, and the defendant had the appeal, and the court sustained the appeal, saying essentially these issues are for the jury, whether or not this non-consensual, intentional conduct amounted to a battery was for the jury. I think Andrews versus Peters helped our case. Now, the second part of your question was,
Is it true though,
is
it true though that in Andrews versus Peters, the plaintiff didn't make a motion such as the plaintiff made here, right?
Well, right, it's the flip side. This was a defendant making the directed verdict motion, which presumably would have made the directed verdict easier because our longstanding case law provides that it's far more difficult and far more rare a set of circumstances in which a court is going to direct verdict for a plaintiff who bears the burden of proof as opposed to a defendant who does not bear the burden of proof.
Wasn't there an issue in the Andrews case about whether or not this prank that the defendant pulled, because it was simply a prank, whether or not that satisfied the intentional bodily contact? And didn't the court say, citing the restatement, a bodily contact is offensive if it offends a reasonable sense of personal dignity? So, granted, I understand this case went to the jury to decide if the elementary school prank was a battery. Would you agree that firing a pistol at someone and hitting them is a lot more clearly offensive conduct than playing this prank that was an issue in the Andrews case?
The magnitude of the injury that you would expect to flow from a bullet being fired from a firearm is much greater than the prank in Andrews. However, the circumstances in the Andrews case were totally different. Here, if we accept the defendant's contentions, if they're deemed true and in his favor in all reasonable inferences, in this case, the trial court was looking at a situation where the plaintiff left. The defendant thought the plaintiff was gone. Instead, the plaintiff, he testified, he had an explanation for it. He had to do a U-turn in the parking lot because he was pulling a long trailer and he didn't want to hit any cars. But he ends up practically right next to where the defendant was. He gets out of his car. He's angrily advancing while cussing and holding a metal bar that both he and Detective Arthur testified would be a deadly weapon. The plaintiff testified he could kill a man with that.
Mr. Thorpe, if I could just interrupt you, sorry. I understand what your argument is, and if we were here on a criminal appeal and your client had been convicted of criminal battery, there are lots of cases about the intent requirement and the mens rea requirement for criminal battery. Do you agree that civil battery has different elements that are not identical to criminal battery?
I would agree that there's a different standard, and that it's beyond a reasonable doubt in a criminal case. It's by a preponderance of the evidence in a civil case. The point here
I could
is
just follow that up. In a criminal case, I don't know if I've seen this in a civil case, and tell me if you think it has no application. In a criminal case, our courts have held that a defendant who has a defense of self-defense to an assault or a murder or anything isn't entitled to a self-defense instruction unless the defendant first admits that he or she committed the assault, that he or she intentionally assaulted the other person. And didn't your client in this trial admit, I get that his reason was self-defense, but did he not admit that he intentionally caused a bodily contact with Mr. Simmons?
He did not admit to battering Mr. Simmons, as battery has long been defined under our law. And in fact, he argued at page 442 of the trial transcript, paragraphs 8 through 10, that is a valid question for the jury to determine, and I believe the issue should be submitted to them for their determination. He's argued since trial, and that was right before the plaintiff moved for directed verdict on battery, despite the fact that in the pretrial agreement, they agreed the first issue was going to be, was there a battery?
Mr. Tharp, didn't he admit in his verified answer that he intentionally shot the plaintiff?
He did shoot the plaintiff. There's no question about that. It's uncontroverted.
And he did it intentionally.
He did it to stop the plaintiff's progress towards himself and Ms. Clark with the metal bar.
So wouldn't the proper issue be like there was a battery, and then the question for the jury would be whether or not it was self-defense or defense of another?
The first question for the jury would be, was, in the totality of the circumstances, was what happened was the contact that the defendant caused with the plaintiff, which was the shot. Did that amount in those circumstances to a battery? The way the question would be framed in the case would simply be, did the defendant, John Wiles, commit a battery against the plaintiff? And that's not verbatim, but that's how the issue looks in the pretrial agreement. We have a situation where a defendant proceeded through trial, didn't object to numerous things such as the police investigation, numerous mentions of the police, an interrogation by the police. He didn't attempt to get in some video evidence showing him leaving the police station. He didn't attempt to represent to the jury that he was never charged criminally. He made all these decisions on the basis of this is going to be like any other battery trial, which is the jury is going to decide whether there's a battery, and then, only then, do I have to worry about my affirmative defenses. Now,
Mr. Tharp, would you agree that?
May I have a question?
Go ahead.
So, am I understanding that your argument is that this was not a battery because your client did not possess the requisite intent?
yes.
Okay, thank you.
Well, I have a question. How do you respond to plaintiff's argument that you're swapping your horses on appeal? That before the trial court, you argued consent, and
Yes.
before the Court of Appeals, you're arguing intent.
Thank you, Judge Zachary. I reject that characterization. At trial, the defense counsel for Mr. Wiles argued at page 440, paragraph 19 of the trial transcript, that Mr. Wiles, quote, did not commit an unlawful act. He then argued at page 441, paragraphs 20 through 25, that it is a question for the jury whether or not they think by his actions there was no other choice but for John Wiles to act the way he acted. Further, page 442, paragraphs 3 and 4, plaintiff has the burden of proving that this was an unlawful act. Finally, page 455, paragraphs 11 and 12, quote, that's part of the elements of tort. We rely on the common sense of jurors to say whether or not this is a battery. So I reject the contention that there was no argument made by the defendant about intent. And furthermore, the question is not whether the defendant objected to the directed verdict motion of the plaintiff on the basis of intent. The question is whether the defendant objected to not submitting the issue of battery to the jury, and he did. And that was the quote I read earlier. It is a valid question for the jury to determine, and I believe the issue should be submitted to them for their determination.
Mr. Tharp, I just want to make sure that we have time to cover some of your other arguments. You also are appealing from the trial court's denial of your client's motion for directed verdict affirmatively on his affirmative defense of self-defense.
That's correct, Your Honor.
Anything that you feel like you need to argue about that issue that's different from what you're arguing about the directed verdict on the battery claim?
I think I can cover that in the context of the defendant's argument regarding the trial court's refusal to grant his directed verdict or JNOV regarding punitive damages, because the evidence addresses, the evidence is the same for both issues.
And if I could just ask you, I noticed that your reply brief is limited to the preservation issue and the intent element of battery. So are you going to address plaintiff's arguments regarding the punitive damages here?
Yes, at page 21 of the plaintiff's brief, he argues that the defendant has only challenged damages in the context, no damages in the context of the defendant's directed verdict and JNOV motions regarding punitive damages, and only challenged compensatory damages in the context of the new trial motions. And this comes down to an issue of that missing page, if you will, of the second order, which was 23 April 2019. The first order that covered the punitive damages issue was 23 January 2019. That page of the order is now either page 83A of the record or 55 of the record. Those two pages are identical. And here's why the defendant did argue about all of the material that's on that page of the court's order. As to paragraph 1 of the court's order, which you'll find in the record, page 55 or 83A, the court speaks about the anger, the malice that the defendant had.
Oh, I'm sorry, sir. I'm not asking about what was argued before the trial court. I just wanted to be clear that even though your reply brief didn't address the plaintiff's arguments regarding punitive damages, motion for new trial, and denial of a directed verdict, are you content to rest on your brief, on your initial brief, or is there something that's not said in your initial brief that you want to address now?
Well, the response to the court found what supported punitive damages and therefore would also served as the basis of the denial of those motions brought by the defendant is the same set of facts. And so the reason why, and I'm addressing this towards the plaintiff's motion, the defendant's motion for directed verdict and JNOV on punitive damages, both the submission of the issue to the jury and the sufficiency of the evidence. With respect to the malice element, which is addressed at paragraph 1 of the trial court's order on page 55 of the record, defendant ran around the back of his car after he perceived the threat. He yelled, "Stop," twice. Clark was screaming. The defendant was frightened by Clark's screaming. The defendant perceived plaintiff as an immediate threat to both himself and Clark. He held the gun with two hands to keep it steady. He aimed in a non-lethal way. He said he intended no harm to the plaintiff. He said his intent was to stop his advance. The only witness that was there on the scene that day that testified about anger was Mueller, the store employee, who said there was no anger. All of this
I just want to make sure I'm understanding this on the punitive damages issue. On the punitive damages issue, is it your position that our standard of review of all the evidence in this trial should be in a light most favorable to the defendant Mr. Wiles, or in the light most favorable to the plaintiff, Mr. Simmons?
Well, the standard of review with respect to the punitive damages should be in the light most favorable to Mr. Simmons.
To Mr. Simmons, the plaintiff?
Yes.
Okay, so didn't Mr. Simmons give a very different account of how he came to be shot? And didn't he testify that Mr. Wiles said something said die to him after he'd been shot?
Mr. Simmons did testify to that. Of course, Mr. Wiles denied that he made that statement, but there just wasn't any basis for the court, after directing verdicts on battery, to then leave the defendant exposed to punitive damages. The trouble there was the defendant's entire trial presentation hinged on his assumption and the agreement in the pretrial agreement that the jury was going to consider the battery issue. And being deprived of that, he allowed a lot of evidence to come in. He didn't object to evidence. He didn't present evidence. And this caused prejudice to the defendant.
Well, Mr. Tharp, your client was represented by counsel at trial, right?
He was.
And don't trial counsel understand that until motions for directed verdict are presented to the trial court, that you really can't know what's going to happen?
That's a fair statement, Your Honor. Regarding the punitive damages issue, all of the issues related to the court's order, page 55, page 83A in the record, are addressed by the defendant in his brief, pages 5 and 6, 12, 19 and 20, 21, 30. The defendant has challenged the denial of his directed verdict and JNOV on punitive damages and the submission of the issue to the jury, and has preserved it for appellate review, given those arguments in his brief.
Would you like to save the rest of your time for rebuttal, in addition to the 5 minutes that you're allowed? Thank you.
Yes.
Thank you very, very much.
Thank you.
We will now hear from counsel for plaintiff appellee Tony Ray Simmons. And if you'll please just be sure to introduce yourself.
Thank you, Judge Inman, and may it please the court, and good afternoon to you all. My name is Lucas Baker, and of the Cabarrus County Bar, I represent plaintiff appellee Tony Ray Simmons, Jr. We are here before the court today to ask that this court affirm all of the decisions of the trial court below, and by doing so, find no error and affirm the judgment. A couple of factual points that I just want to get addressed very quickly here at the outset. Mr. Tharp, he may have just misspoken in accounting what happened when the parties entered the Northern Tool store. I believe it was said that Mr. Simmons entered the store 13 minutes after Mr. Wiles. If you refer to the documentary exhibits, plaintiff's exhibit, I believe it's plaintiff's exhibit P, which is a series of screenshots that definitively shows that Mr. Simmons entered the store first, and it was after that Mr. Wiles, the defendant, entered the store. So I just want to make that clear. Another aspect of the facts is what I heard being said, that the first time that the defendant and the plaintiff had met was inside the store. However, if we view the video of the police interview following the shooting, the defendant identifies several encounters that they had. So they had met each other before. Also, Ms. Clark testified that she was not present. This is her live court testimony, that she was not present during this encounter when Mr. Simmons allegedly, according to Mr. Wiles, was quote unquote making threats or engaging in some other type of behavior. Now, having addressed those issues, I want to turn now to the real issues that are before this court in the context and standard of review. On the issue of granting a directed verdict in favor of the party with the burden of proof, that's the defendant's first criticism of what the trial court did in granting a directed verdict on battery. And, you know, I concede, and we always have, that battery is the plaintiff's burden of proof. However, in the North Carolina Supreme Court's decision in Burnett, the National Bank something versus Burnett, as Your Honor, Judge Inman pointed out, there are the rule that generally you don't direct a verdict in favor of the party with the burden of proof is not absolute. There are circumstances where that's appropriate and called for. We respectfully submit to this court, as we did in the court below, that this is one of those circumstances.
But would you acknowledge that our courts have said this is very rare?
Absolutely, I would. Absolutely, I would. However, even before the adoption of the North Carolina Rules of Civil Procedure, and this was submitted in a in Plaintiff Appellee's Memorandum of Additional Authorities that was filed yesterday, I was able to locate the case of Robertson v. Stokes, 181 NC 59, 106 SE 151, a decision of the North Carolina Supreme Court from 1921, which, in reading the case factually, it's not exactly the same, but it's very similar. And it's similar in this respect. The plaintiff in the Robertson v. Stokes case claimed that he was battered or assaulted, was the word that they used in the decision, by the defendant and the defendant's son. During the trial testimony, the defendant's son admitted that he, basically struck the plaintiff with a brick. And, in instructing the jury in that decision, the trial court instructed the jury that it was plaintiff's burden of proof to essentially negate the defendant's theory of self-defense. And what the North Carolina Supreme Court very plainly said in the second to last paragraph of the decision, as to defendant W.F. Stokes, that's the son, we are of the opinion that the judge erred in stating that the burden of proof was upon the plaintiff, as W.F. Stokes, the son, admitted that he assaulted the plaintiff. And this admission shifted the burden to him. Now, granted that we're not dealing with a case that applied the concept of a directed verdict, but I believe, I respectfully submit to the court that had we had the rules of civil procedure at the time that this case was decided, that case would have been one where a directed verdict would have been proper for the plaintiff, given the trial admission of the defendant that he struck the plaintiff. And that's essentially what we have here. We have a defendant who, admits and conceded in his trial testimony that he shot the plaintiff, that he aimed and purposefully, caused a bullet to leave the gun and impact the body of the plaintiff, my client, Mr. Simmons. So And that's enough. That is the standard for the intent element as it relates to common law battery. There is no requirement that there be a hostile intent. There is no requirement that there be an intent to injure. There is only the requirement, per Andrews v. Peters, that there be intent to bring about bodily contact. So the intent element, when the judge is viewing the evidence in the light most favorable to the non-moving party, which is the standard, in this case, that would be in favor of Mr. Wiles, giving him the benefit of assuming everything he says is true and drawing all inferences in favor of him. Even according to his own testimony, he concedes he shot the plaintiff and it wasn't an accident. It wasn't a, oh, well, you know, I thought the safety was on, but it wasn't. And, you know, and the gun went off accidentally. There's no negligence. There's no nothing. He was very clear that he aimed and shot the plaintiff on purpose. So given that that's the case, you know, the judge did comply with the standard, and viewing the facts in the light most favorable to Mr. Wiles, a battery occurred. The only real issue for the jury to decide, and, you know, the plaintiff did not move for a directed verdict on the affirmative defenses because there was competing evidence that the jury had to weigh and decide based on the credibility and weight to be given to evidence. The issues to be decided were what were two things: whether the battery was legally justified by self-defense or legally justified by defense of another from a felonious assault. And this defendant had the benefit of being able to put on all the evidence necessary in order to meet those issues, argue them before the jury, and the jury did not decide those issues in favor of this defendant, on which he had the burden of proof. So, you know, on the first issue, I respectfully submit to the court that it was indeed proper, and I submit further, it was required for the trial court to grant plaintiff's motion for directed verdict on the issue of common law battery. There was no dispute, even viewing everything in the light most favorable to the defendant, that, you know, a battery had occurred. The only issues were whether there was a legal justification for the commission of a battery, and those issues went to the jury. On the second avenue of attack here is on the punitive damages issue, and there are points in the defendant appellant's brief where he makes comments about the trial judge's adoption of a one-sided view of the evidence. In both the judgment that was entered on the verdict and the judgment that was entered after the hearing on defendant's motions for new trial, the trial court performed its statutory obligation to give a written opinion of its decision on whether to uphold or disturb the decision of the jury to allow punitive damages in the verdict, and the amount of the punitive damages allowed in the verdict. The trial court was very careful to very properly note that, you know, what it was setting forth is not necessarily the court's opinion. It is the review of the evidence to support the decision on whether or not to disturb the decision of the jury or not, as it relates to punitive damages. So the trial court necessarily had to look at it according to, okay, well, the jury has decided that that the defendant did not meet his burden of proof in his proving his affirmative defenses of self-defense and defense of another from felonious assault. So, you know, and they obviously found that, well, we're going to decide to award punitive damages and the amount is $2 million. So the question then, in the standard of review, make no mistake, is whether there was clear and convincing evidence to support the decision and to
That's a
support.
higher, just to be, and that's a higher standard than we normally apply, right?
That is correct.
Other damages?
Absolutely correct, Judge. Absolutely correct. And the case law makes it clear that because of that higher standard, it's not a, view it in the light most favorable to the, to the non-moving party. It has to be, was there clear and convincing evidence to support the finding of the aggravating factors, which in this case, the aggravating factors that went to the jury were malice and willful and wanton conduct. Now, as to malice, we respectfully contend to this panel and to this court that there was ample, copious amounts of evidence. A great bit of it is found in the video of the interview with Mr. Wiles that was taken post-shooting at the Concord Police Department. Mr. Wiles is asked what happened, and he's asked to give a little bit of backstory, and he goes on for quite a long period of time talking about various events that have caused him to have a very low opinion of Mr. Simmons, my client, the plaintiff. And he basically, believes he's a liar, a cheat, a fraud, and at one point during the interview goes as far as to say, doggone it, we're tired of taking his, I'll not restate what was actually said. So, that evidence right there of the defendant's own ill will held towards the plaintiff based on these previous encounters were the defendant's own admissions of his ill will towards the plaintiff. Now, taking it to the next step, which is, did that ill will incite the defendant to act? There was more than sufficient evidence to support that element of the malice finding, clearly and convincingly. Because when we go back and appraise the series of events, we have one, Mr. Simmons is the first one to go into the Northern Tool store. All right. Two, we have Mr. Wiles following behind. And then after more or less 3 minutes, when you watch the video that was published before the jury, which is contained on that USB drive, that video shows the defendant, and plaintiff's exhibit P shows the defendant approaching the plaintiff inside the store. Now, I understand there's Mr. Mueller's testimony that he didn't detect any ill will, but he was told by someone that they're about to fight. So there's that aspect of it. And looking at the video further, we can see where Mr. Simmons is trying to go away, but Mr. Wiles continues to give chase. And the reason why Mr. Wiles is giving chase and is, trying to continue this verbal confrontation in public inside Northern Tool is because Mr. Wiles is angry about he and his family being sued by the county for zoning violations. And if you look at the testimony of Richard Cook, who was the county attorney on that particular case, which was presented via deposition, Attorney Cook explains what the litigation was about and how that litigation resolved in a consent order, and how Mr. Simmons was one of several neighboring landowners who had given affidavits to support the county's the county's case about the defendant and his family's improper use of the land as a salvage yard, parking multiple vehicles on it, and the environmental concerns about the well water, things of that nature. And Mr. Simmons' affidavit was indeed placed into evidence. And that was what the confrontation was about. And the consent order that had resolved that litigation, that that happened, I believe, if memory serves, and forgive me if I'm not correct on this, in either March or April of 2009. So for the 6-month period of time between entry of the consent order, which resolved that litigation, up to September 19, 2009, the defendant had been basically had shouldered the responsibility of cleaning up the property. Every time that the defendant would go to clean up the property, he had to drive by Mr. Simmons' driveway. So there's more than, the point is that there's more than sufficient evidence that Mr. Wiles really didn't like Mr. Simmons, and further that sense of personal ill will, as evidenced by the encounter that happened inside Northern Tool, was what incited him to act. We fast forward after the encounter inside Northern Tool, Mr. Simmons stays inside the store for 8 minutes. 8 minutes he stays inside the store to try and make sure that there's not going to be any further confrontation.
Do you acknowledge that Mr. Wiles testified that he was waiting because Ms. Carter was afraid of Mr. Simmons and wanted to just see what he looked like?
I acknowledge that's what he said. Yes, that testimony is in the record. Query whether that was believable, and I believe the jury rejected that testimony, but yes, that's why. That is the stated reason why. And that's why, instead of remaining in his parking place where he was when he originally pulled up, he moves the car to another parking place, where they can try and watch from a distance. And then, basically by happenstance, Mr. Simmons, because he's trying to check a chain that, a loose chain, and that there was a photograph that's in the record on appeal. He stops his vehicle to try, with the intent to try and tighten the loose chain, because now he has a breaker bar. He's going to knot up the chain and use the breaker bar to crank down on the mechanism, which operates kind of like a ratchet strap, if you will. And he comes around the front of his car, and there is the defendant continuing the verbal confrontation from inside the store. So, and we know what happened after that, and understanding, and I get that Mr. Wiles does not agree with my client's version of events, but that's what juries are for, right? So the jury rejected the defendant's version of events and accepted plaintiff's version of events, and there was ample evidence to support the idea that the malice, that sense of personal ill will that Mr. Wiles felt towards Mr. Simmons because of his role in causing so much trouble for his family over the years, and causing he and his family to be sued, and causing him to have to clean up the property and remove vehicles from the property, that's what incited him to act in anger over what had occurred. So we respectfully submit that there was that the standard for clear and convincing evidence as to malice was absolutely met, hands down. There was clear and convincing evidence of an intense amount of dislike, and through the years and recently, that would incite Mr. Wiles to act in committing this battery upon the plaintiff by shooting him in a public parking lot on a Saturday afternoon in Concord, North Carolina. So moving on to willful and wanton conduct. A lot of the same facts or evidence that supports the finding of malice also goes to support a finding of willful or wanton conduct. Because what we have here is somebody who has, in a public parking lot in the middle of the day, aiming a gun towards a busy main traveled highway in Cabarrus County, Concord, North Carolina, is pulling a gun and firing it. Now, Mr. Wiles testified that he aimed for the largest part of the body that he could, strike the plaintiff without it being lethal. I believe that the jury heard that testimony and rejected it. Because there's a line in when he's being examined by his trial counsel, he's asked about the heart. Did you aim for his heart? And that bottom line is he fired the gun at the plaintiff. Now, if he had missed, where would the bullet have gone? And if you have a look at the photographs taken from the defendant's POV, that is point of vision or point of view, if he had missed, that bullet would have gone straight down to Highway 29 and potentially injured another person. So on the willful and wanton conduct issue, there's ample evidence to support clear and convincingly a finding of willful or wanton conduct on the part of the defendant. Turning to the amount of punitive damages. I believe this is in the transcript on the hearing on the motion for new trial. The amount of punitive damages, pardon me, I respectfully submit was, absolutely within the jury's discretion. First of all, it was $1 million in compensatory damages allowed for an injury which has compromised my client's L4 nerve root and caused his left leg to basically it's deteriorating over time and has caused him to become disabled, unable to enjoy what he did before as far as his livelihood as a professional CDL driver who hauled cars back and forth and had a decent business, according to the evidence.
If I could just interrupt you, wouldn't all those damages that you just described fall within the analysis of the compensatory damages?
Actually, no, Judge, because one of the factors that the jury was able to consider in assessing the amount of punitive damages is the likelihood at the relevant time of serious injury or harm. These are the factors that are set forth in Chapter 1D that the jury is instructed that they can consider. Now, the reason why I'm talking, though, about those compensatory damages is because the $1 million was more than justified based upon the evidence. I asked for $5 million, and I respectfully submit the trial counsel did a good job of holding that verdict down. Now, $2 million is less than 3 times the amount of compensatory damages. So, that is a presumptively, I respectfully submit to the court, as a presumptively permissible type of punitive damage award. And it could have been premised, according to the logic of the trial judge in writing his 1D-50 opinion, based upon what the jury may have perceived as an attempt by Mr. Wiles and his girlfriend at the time, Miss Greta Clark, to conceal his wrongdoing by making up a story about the plaintiff rushing at them with a breaker bar in one hand, like a crazed maniac. The Tony the Barbarian defense is how I refer to this. And, the evidence indicated, though, at the scene, Mr. Simmons had a cigarette in his mouth. He has a cigarette lighter in one hand and a breaker bar in the other. He testified that he never raised it above. He was going to use the breaker bar as a tool because he purchased it at Northern Tool to tighten a chain. So in order for the jury to believe the Tony the Barbarian story, they'd have to believe that Mr. Simmons would go into battle like a crazed maniac with the his mace, if you will, raised upward, while planning to light a Marlboro Red cigarette, on the way to doing it. And the jury rejected that. So I respectfully submit that, the amount of punitive damages, the jury did not abuse its discretion, and the trial court very appropriately recognized that in the 1D-50 opinion. I see we're getting down to about a little less than 3 minutes left, and I can keep going. However, are there any questions that I could answer of the panel?
Are you aware of any cases in North Carolina in which the appellate court has affirmed the ruling of the trial court directing verdict in favor of the plaintiff on a battery claim?
Your Honor, like Mr. Thorpe, I have been unable to find such a case. I'm not aware of it. The closest thing that I was able to find is the Robertson v. Stokes decision from the North Carolina Supreme Court, which was pre-adoption of the rules of civil procedure, which I respectfully submit would command the same result that was obtained in the trial court in this case on the motion for directed verdict standard and on the standards announced and set forth in the Burnett case. All right.
I don't have any further questions.
Okay.
It doesn't look like.
I don't have any, thank you.
I have no questions. Thank you very much.
Very well. Do I need to address the other matters in the minute that I have left?
It's all up to you.
Okay. Well, then just very briefly, the trial court did not abuse its discretion in the 403 analysis on keeping out a certain portion of the interview video. That was completely within the trial court's sound discretion, and it's consistent with, let's see, what's the name of the case? Entirely consistent with the Hennett versus Holland case, which says that we don't admit evidence of not being convicted of a crime or not being prosecuted for a crime. It's not directly on point, but I think it's the decision of the trial court is a logical extension of that. Finally, the trial court properly exercises discretion to deny the motions for new trial. And based on everything that appeared of record, what we have is a clean trial. It was well tried on both sides by counsel of record. And we respectfully ask the court to find that there was no error and affirm the decision of the trial court below. Thank you very much.
Thank you very much. We will now hear rebuttal for the defendant appellant. Mr. Tharp, are you ready?
Yes, Judge Inman. Addressing the Stokes case, as counsel pointed out, is a 1921 case before the adoption of the rules of civil procedure. Cutts versus Casey, it's 278 NC 390, addresses the situation of a directed verdict in the plaintiff's favor. The court reversed a directed verdict. In that case, it was a title dispute. It answered this question: the trial judge can direct a verdict in favor of the party having the burden of proof when his right to recover depends on the credibility of the witnesses. When can the trial court do that? In all caps, the court answered no. Instead, the court said when there's no conflict in the evidence, but one inference is permissible from it, the court may give a peremptory instruction in favor of the party having the burden of proof. However, the established policy of this state, declared in both the Constitution and statutes, is that the credibility of the testimony is for the jury, not the court, and that a genuine issue of fact must be tried by a jury unless this right is waived. So let's look at a case where a court gave just the peremptory instruction. In Your Honor, I think I had 5 minutes in addition to that one.
I think that this was just what was left over from your initial argument. And so if we can set the clock back to,
I guess it's going to run up to 5.
yes. Okay. Please continue, and I'll assure you won't lose any time. Let's just put it that way.
Thank you, Your Honor. So let's address the situation where the court just gave the peremptory instruction, a little bit less than the directed verdict. Clark versus Clark, 47 NCF 249. In that case, the defendant admitted that he held a baseball bat when it made contact with the plaintiff's head. He just denied that he, quote, struck her. The court gave an instruction to the jury saying, if you believe the plaintiff's evidence, you can find in favor of the plaintiff. Court of Appeals reversed that, saying that was an issue whether the defendant struck the plaintiff with the bat, even though he admitted non-consensual bodily contact to her head with the bat. The court reversed that, awarded the defendant a new trial. The Smith case, that's quoted in the defendant's brief, that's at 315 NC 523, the North Carolina Supreme Court case. In that case, a woman sued a man alleging he was the father of her child. The court directed verdict is the JNOV for the woman in the case. She had introduced into evidence a blood test that showed it was 96% likely that the defendant was the father of her child. However, the defendant, the non-movement, admitted the truth of his own sexual relationship with the plaintiff and therefore the possibility of his paternity, but he did not admit that he was the only male that could have fathered the plaintiff's son. So therefore, his non-admitting to being the father, even though it was 96% certain, was an issue of fact for the jury. The court overturned that, awarded a new trial. Now, the Smith opinion gives you the 3 situations where it may be proper for a court to direct verdict in a plaintiff's favor. And I have found 3 cases in North Carolina, they're all cited in my brief, where directed verdicts have been granted for plaintiffs. One is the Fairfield case, which is 215 NCF 66. Another is Chisholm, which is 255 NC 374. And the other is Burnett, which is 297 NC 524. Now, those cases all fall within the 3rd prong of the 3 listed by the court in Smith versus Price, which is, the 2nd prong, where there is controlling evidence, documentary evidence, and the non-movement does not deny the authenticity or correctness of the documents. I'll just mention the Burnett case, since that's the one that came up. In that case, it was deficiency judgment. The question was, did the bank provide notice to the defendant? The bank complied with the statute, sent notice, so therefore there was notice, notwithstanding the defendant saying, well, we never received it. In closing,
If I could just, and where the defendant said we never received it, right? That was a legal issue about whether it mattered that they never received it, right?
Well, right, but there's no opportunity for a defendant to claim, well, I didn't receive this once the plaintiff has complied with the statute, which is I have a valid address, I sent it there, there's notice.
Okay, very well.
Totally different from this case. This case depends on the credibility of witness testimony from one side as opposed to the other, and that's what makes this case totally different. And I think it's going to set a dangerous precedent if the court affirms the directed verdict. I think it's going to do, it's going to transform the tort of battery into something that courts can just routinely find in favor of plaintiffs as a matter of law. And I thought it was telling that you asked plaintiff's counsel, have you found one case where this has been done? And there's not one that either of us can find. In closing, Your Honors, words fail to capture the magnificent complexity of human life. The mind can capture in a few seconds, and reality can inform a human being's senses in a few seconds with information that would take eons to put into words. That's why we have juries. Our pattern jury instructions cannot envision every factual scenario that will arise. Two juries, after an appraisal of the evidence and instruction on law, we say, was this a tort or not a tort? Was this an intentional tort or not? The defendant prays that this court gives him the privilege of letting a jury decide whether this was a battery or not. Thank you.
Thank you so much, Mr. Tharp. And again, Mr. Tharp and Mr. Baker, thank you for your excellent arguments and for joining us on this new adventure in a court session. The case is submitted, and Mr. Horn, we are ready to adjourn.
This session of the North Carolina Court of Appeals is now adjourned.